Hi, Stefano Molea, San Diego criminal lawyer and partner at the law office of David Shapiro, where we help good people regain control of their future when charged with a crime. So what's a preliminary hearing? Sometimes called a preliminary examination, but in court you will hear people say prelim. As we learned in a prior video, during a felony arraignment, two future dates are set: a readiness conference and a preliminary hearing. A prelim is an important part of the criminal process. At a prelim, the prosecution has to put on evidence by calling witnesses and sometimes admitting exhibits to convince a judge that, essentially, the crime probably happened. It's a very low burden of proof, but it serves as a filtering system to make sure that there is enough evidence for every element of the charged crime for the case to move forward to the next stage of the process towards trial. If the judge thinks the evidence is enough, he or she will bind over for trial. Because the prosecution has such a low burden of proof at a preliminary hearing, some may think, well, it's not that important, the judge is just going to bind over, so let's move the case along. Anyone who thinks that would be sorely wrong. First, a prelim is a time to get a live preview of the state of the evidence, and most importantly, to test it out. You see, the defense gets to cross-examine witnesses and stress test the prosecution's case. If through preparation and analysis, the defense can show that the prosecution failed to present sufficient evidence, then the charges and/or case can get dismissed. At a prelim, for charges that qualify as wobblers, the defense could even ask that a charge be reduced from a felony to a misdemeanor. So this is just a summary of what a preliminary hearing is and what it entails and why they're important. Hope it was helpful. Have questions? Give me a call. Stefano Molea, criminal defense lawyer in San Diego, 619-295-3555.